Okay, I think it's 4:30, so we'll go ahead and get started. We'll call the meeting to order. You received the minutes of the previous meeting via email. Are there any additions or corrections? If not, do I hear a motion to adopt the minutes as emailed?
So moved.
Is there a second? Motion's been made and second to approve the minutes as emailed. All in favor signify by saying aye.
Aye.
Opposed, same sign. I think you've had a chance to look at the proof of publication and the notice of public hearing affidavit. Do I hear a motion to make those a matter of record?
So moved.
Is there a second?
Second.
Motion is made and second to make the proof of publication and affidavit, notice of public hearing, matter of record. All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carried. Okay, before us this evening, we have Innovative Concepts, Audio Video Incorp., 1421 Manchester Street, Decatur, 46733, requesting site plan review to construct a 40 by 80 by 16 pole barn storage warehouse at their building, reference to City Code Section 150.330. We'll let the applicant make the presentation. Would you like to?
We're just requesting permission to finalize the plans to put up the pole building. It's going to be kind of adjacent and behind our existing structure. Its primary purpose is going to be for warehousing and storing inventory of our electronic products so that we can free up that warehousing space that's currently in our existing building to eventually plan 2 will be then to ask to do renovations inside for boardrooms, conference rooms, additional showrooms, and retail space. So, but the first step is to get all the product in the building now into a new space for more organized storage and easier process and handling of inbound inventory as it comes and goes. So I guess that's really what we're requesting is we started this process a while back. We've gotten a state permit approval from the state of Indiana and site plan approval from them, and we're requesting whatever the next step is here, building permit to begin as soon as possible.
Okay, the board members, any questions of the applicant?
How soon were you planning for construction?
I don't know what the ground and weather's got to permit now, but we're ready to break ground as soon as we possibly can. It's phased badly, so as soon as Arnold Construction is who we've chosen as the contractor to erect the structure, so just as soon as they can get it in their schedule and we have legal permission to proceed, we'd like to get it started.
I think it's a great idea, Chris. I've been to your place a few times, and you are in dire need of extra space. So
We are, yeah. I've probably been conservative too long.
exactly.
Time to do something.
Chris, we know who you are, but for the record, would you identify yourself for us, please?
Yeah, Christopher D. Caston, and my wife Tina. I'm president of Innovative Concepts Audio Video Incorporated.
Thank you. Any further questions from the... Okay, if there are no, let's see if there's anyone in the audience who wishes to speak in opposition. Hearing none, is there anyone who wishes to speak in favor? Seeing and hearing none. Kurt, Kurt, do you have anything that you wish to comment regarding the situation?
This is cold storage for now.
That's the plan right now. We really would, we're using a storage container and a portable shed right now as some cold storage, and then the rest is inside, and we just need more space. And so our plan right now is cold storage. I can't say that down the road we won't maybe do more with it, but at this point it's cold storage just to get racking and inventory space.
You do realize down the road if you do make significant changes on the inside, it could change the occupancy of the building, and you may have to submit to the state for a change of occupancy. Or if you section the building off to where half of it is storage and the other half is boardroom, conference room, office space, whatever, you'll have to submit for a split or dual occupancy.
Okay. And there would never be anything other than storage out there or vehicle storage and parking inside. The boardroom and conference room and retail space would be in our existing building now that we have. Just right now, those spaces are being occupied for product storage.
Okay. Good.
Kurt, are you okay with final site plan approval on what you've seen?
Yes.
Okay.
Okay, any final questions or comments from the board members?
No.
No?
I guess maybe one question.
Yeah.
Chris, have you, this is a relatively large structure, drainage and everything, are you comfortable with your drainage situation?
I think so. From what the contractor has looked at on site and the conversation I had with the engineer that did the site drawing for us, it seemed that the elevation was fine and the runaway would be, would work with the existing structure and parking areas that we have there currently.
Okay.
Kurt, has Don had a chance to look at anything or not?
I have not had any conversations
Okay.
on the project.
Yeah, Chris, you might want to get in touch with Don Bergdahl or have your engineer architect do that. Just make sure that that's
Okay.
okay with him.
Okay, if there are no further questions or comments, what are your wishes?
I make a motion that we approve this project for Chris and Tina Caston.
As final plan,
As
Final
yeah,
plan.
As final plans go through.
I'll second it.
motion's been made and second to approve the plan as the final plan for the innovative concepts. Any questions? All in favor signify by saying aye.
Aye.
All same sign. Motion carries. You're ready to go.
Thank you.
Thank you.
Just
Glad to see growth.
The next step would be then just to come up and apply for the building permit.
yeah. Good thing you brought Tina, because that's why you got it. So.
I'll stick to the technical things.
He knows how this works.
Chris, when Tim asked you to check with Don Bergdahl,
Yep.
you knew who Don is.
Well, I know who he is. I don't.
Don's kind of in charge of stormwater runoff and that
Okay.
type of
Yeah.
thing.
Okay.
So he would have a...
He's going to be here at 5 o'clock. I'll say something to him.
Okay.
We'll have him look at this and then if there's any questions, we'll go over it.
Okay. All right. So you'll follow up with me if you have
Yeah.
questions or concern. Okay. Very good.
Okay, thank you very much.
All right.
Glad to see growth. Okay, is there any old business? Anything else we need to discuss? Kirk, do you have anything left from old business that we need to consider? Tim?
I have a couple of things on new business. So.
Okay. Moving on then to new business. Tim, you have a couple things?
Yeah. To bring the Plan Commission up to speed on a matter that has arisen, you're aware that North Adams is doing a major project out on the campus at Belmont, and then the hospital likewise is doing one at Woodcrest. In the course of issuing permits, it became apparent that when you get into very large projects that our permit fees become somewhat out of line from what they should be. So we've looked into this, and Kurt and Sharon have spent a lot of time on this, and the mayor and I have had some conferences as well, and I think the end result is that there is general consensus that there should be some type of cap put on permit fees for terribly large projects. Typically, if it's under $5 million, it doesn't generate a problem, but when you get up to 20 or 30 million, then the fees become pretty significant. And it's the way our fee structure is set up. So after looking at this and looking at what our costs would be for administrative expenses as well as investigative expenses, so when Kirk goes out and does an inspection, there's a cost to that. The city, the Building and Planning Department is recommending that we put a cap of $25,000 on all permit fees for a particular project. And that would then address these large projects. We don't have to worry about residential projects or even commercial projects that are well below those figures ever hitting this cap. But on those big projects, that happens. So I guess what I would like, if the Plan Commission is inclined, is to agree to that cap and recommend that council adopt an ordinance to amend our code to put that cap into place so that it goes into effect and applies to the Adams Memorial Hospital project as well as the North Adams project. Otherwise, we're going to end up charging them pretty significant fees, and that's not our intent. We're not trying to make money. We're here to cover our expenses.
And this would apply to the projects that are already underway?
Yes.
And it would also affect one other project that's going to happen this year, I believe, and that would be the...
Possibly it would be the...
Here and the apartment, what's that?
What, the Artist Lot project?
Artist Lots in Country.
It could, depending on the size of the cost of the improvements.
The only question I have, is that legal to change that during the middle of
Yeah,
construction?
I spoke with Terry McCardwell down at the State Board of Accounts, and he said that was not an issue for them.
So we could probably lower but couldn't increase.
Yeah, I mean, at this point, what we're doing is we're trying to be reasonable and fair. We're not trying to, pad our coffers. It's basically designed to cap permit fees at a reasonable sum that would address the needs of the city, but also not make it burdensome on people that are doing large projects.
Okay, so I guess, there's further questions, comments?
What kind of numbers are we talking about as far as the max?
$25,000. And that's a total of all permit fees.
So the North Adams project would have come in excess of $100,000
Over that.
with,
Well, the way PSI figured it, they figured it 200, but in all reality, it would have hit probably just a little over 100,000.
Right.
so just to make sure I'm understanding all this, approximately 3 to 4 years ago, City of Decatur underwent a fee restructuring.
Yes.
And at the time, I remember the Plan Commission, we actually applied some of those fees to projects that were in place at the time, but there were no major large projects.
Correct.
So in validating the numbers to make sure we were in line with surrounding communities,
That was the intent when we
that was
did the
our
change.
intent.
Yeah.
We did not have large projects at the time to go through and validate it
Right.
with. So it just slipped through the cracks.
It's just the nature of how the calculations work out on large projects. It has an exponential factor to it that increases the cost significantly, and it gets it out of line. So to avoid that happening, both on these projects and any future projects, at this time, that's the recommendation. We may very well, when we have more time, study our rate structure, maybe make some changes in the structure itself.
But you're saying that would include basically anything over 5 million.
It's gonna, I don't know what the exact number is when you hit where it starts going up, but we haven't had any projects that would have been that significant other than the 2 that we currently have ongoing.
Yeah, the Wendy's project was roughly 2.2.
Yeah.
And they didn't sneeze at it. But what we found is when we get a little bit higher than that, around $4 or $5 million, then the numbers start going way up.
So, and based on this discussion and the original intent of the revision of fees was to bring us in line with surrounding communities, I think it is justified to make this recommendation to Board of Works City Council to put the cap in place that has been approved by the State Board of Accounts.
I just got one question though, is when we cap it,
So you're going to cap it on North Adams, and this first phase is done, they get a cap, are they not going to pay any permitting fees for the next phase, or
No.
you're going to break it?
They're for what the 4 projects that they have going as of now would be the elementary school, the walkway area between the junior high and the high school, and the cafeteria. Those are considered one. And then they have the renovation for the junior high, and they have the sprinkler system for the high school. Will be capped, that entire thing will be capped off at $25,000. Now, there are rumors that there's potential for a new football building that we're going to treat differently.
Mhm.
I guess we got to have our ducks in line on when we're going to separate it, especially with Woodcrest, because they're only in phase 1 and they're going to add another phase. Are we capping the...
Woodcrest is involved in this as well.
Right.
I understand that, but are we then saying that their permit fees are $25,000 for as whatever they want to do on that property?
For those projects, for what they have approvals for now.
Right, it's-
What they have brought to the Plan Commission.
Right.
Just
it's
what
not-
is brought, so when they come to the Plan Commission for the... Because I don't think that back wing wasn't brought in front of the Plan Commission, was it?
It was, but I don't think we approved it because they couldn't give us an exact square footage on it.
Right, because we just approved a little bump out cafeteria thing.
But when you do, there'll be no charges, right? Actually, we're going to refund them a little bit.
That's correct, about $1,000. They're already about 26 and some change.
Did you take into account those other ones? Do you think would still be sufficient to inspect all these other...
Yeah, because I'll give you an example right now with North Adams Community Schools. 47 inspections to date. And even if I hit 100 inspections, that's still $250 per inspection. And the longest I've been out there at any given time is maybe an hour and a half. So $250 for an hour and a half, pretty good money.
Then that includes administration and
Right,
liability, and
right.
so it's not just your salary.
Oh, I know, yeah.
It'd be nice.
It's still good money, though.
Any further discussion? Do I hear a motion then to recommend to the council?
I thought we did.
Did you use that as a motion?
I don't know that I made a motion. I tried to clarify the point. I would be happy to turn my statement into a motion for consideration by the board.
Is there a second to that motion then?
So moved.
Okay, motion's been made and second. Further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries.
Okay.
Okay, Tim?
The other thing that I'll bring up briefly, this regards the project for the new well or water plant. Right now, the city farm is in the county. It's under county jurisdiction. It's zoned agriculture, and there's some discussion about whether we may wish to annex a part of the city farm to bring it into the city so that plans will ultimately come before the city plan commission as opposed to the county plan commission. We're still sorting that out and whether there's a need to do that, but if that happens, then obviously that will come before you. So I'm just giving you a heads up that that's a possibility, and we'll know a little more here probably within the next month or two. Okay.
Okay, anything else? Any other new business? Anything else to be brought before the Plan Commission? Hearing none, then I will accept the motion to adjourn.
So move.
Motion's been made, is there a second? Motion's been made, second to adjourn, all in favor, signify by saying aye.
Aye.
Opposed, same sign. I should have asked, do you have anything else in plan? Any other meetings planned? Okay, thank you all.
Per my phone, it is 5 o'clock. I would like to call the Board of Zoning Appeals of the City of Decatur, Indiana to order. And we've got some housekeeping to take care of first. Each of you received the minutes of the previous meeting. Would like comments or a motion to approve the minutes as distributed.
You need that to write on.
The meeting would have been January 2nd.
Make a motion to approve the minutes as submitted.
Second? Second. Those in favor? Aye. Approved. Per discussion with Tim Baker, attorney, we are preparing a notice that itemizes how this administrative meeting was notified to the public, that we had to do a 48-hour notice rather than the legal notice in the paper. That is being prepared. I would like to have a motion that that document be submitted for record.
And Sharon, if you would, identify the locations where the meeting was posted, and then you also sent a notice to the newspaper as well, correct?
City Hall, the Decatur Public Library, and also the Adams County Courthouse.
And that was posted at least 48 hours prior to today's meeting, okay.
Okay, do we have a motion that that be made a matter of public record?
So moved, Mr. Chairman.
Second.
All in favor?
Aye.
Okay, I'm going to turn the meeting at this point over to City Attorney Tim Baker to enlighten us as to what we're talking about this evening.
Okay. I appreciate, first of all, everybody being here. I'd like to introduce Bob Ehrman. Bob is an attorney up in Fort Wayne with Heller and Colvin, and we've asked Bob to come down. We've spoken with him previously about two matters that have been ongoing concerns within the city, and I think it's important that we take some action. Bob is very well-versed in this area, and that's why I asked him to get involved. To be honest, I've got a lot of things on my plate right now, and I need some help. So I appreciate Bob's willingness to help out the city. The two issues that we've talked to Bob about is the Cottonwood Estates, the mobile home park out on 13th Street, and the Gamble property out on 10th Street. And at this point, what we've been discussing is how to try to address those issues. There's an ongoing lack of cooperation by the owners of those two properties in terms of compliance with either the special use exception that was granted in the case of Gamble, or in the case of compliance with zoning matters in the case of Cottonwood Estates. So we sat down a week or two ago with Bob and discussed this, and Bob, I think, has some ideas about how to proceed. So the purpose of tonight's meeting is, one, to authorize Bob to get involved, and secondly, authorize him to seek court relief in the manner that he may suggest. So Bob, I'll turn it over to you.
Thank you. Let's go ahead and start with the special exception that was granted to Mr. Gamble on 10th Street. I have looked at the entire file. That was approved in January of 2016. He was granted a special exception for a home occupation. Your ordinance defines a home occupation as a business that is actually associated with some type of a residential use. From what the photographs that have been shown to me, that this business has, or the home occupation is no longer a home occupation, it's a full-grown business that's been operating. The BZA put two conditions on the special use. One is that he wouldn't park customer vehicles in the street, and that he would keep them to a maximum of 4, because he said he was going to have 4 customers out there during the day, and he would be able to fix those up. At least from the photographs that I've seen, there have been numerous vehicles there and parked in front. And then also he would attempt to take his personal vehicles and put them on his property. There's two parcels you're probably well familiar. There was a garage built on one lot, his house is on an adjacent lot. So to keep his personal vehicles over at his house, keep no more than 4 there. Since then, it looks as if he's purchased additional lots. Looks like we've kind of got a little creep going out onto these lots as far as going out. So the thing I talked to Tim about was the BZA has the jurisdiction to enforce its own special exception. That is, there was a special exception granted for home occupation, meaning that it would be ancillary to the residential use, somebody doing a workshop, and not be any bigger, and to follow the conditions. So my understanding is that there have been some requests to, and that there hasn't been any cooperation. So the first step would typically be, if you go into court, the Board of Zoning Appeals, as the enforcement authority, could go in and ask the judge to enforce the terms of the special exception. The other options we had talked about were if you thought the compliance was so bad, you could actually try to seek and revoke the special exception, which would mean he would not be able to do anything there anymore. In talking with when talking with Tim, I think we thought that the BZA trying to enforce a special exception would be the best way. That is, we would go into court, and then typically the judge would say follow the special exception. If you didn't, then you'd have the authority of the court to do that. So for that one, that was really the kind of strategy that I had suggested, and that is to allow him to continue his home occupation, but under the terms that you approved. And if that doesn't work for his business, then he probably needs to locate his business places where businesses are located and are zoned for it. So that was kind of my suggestion, and I'm certainly willing to answer any questions, but it seemed to me that that would be what the course to do, is to enforce the home occupation.
And Bob, if you do that, what you're doing in essence is going to the court and seeking an injunction to enjoin him from not following the special use and the conditions tied to it, and possibly entering into an agreed order with him that might even impose other conditions.
Sure.
That could also include the possibility of revoking the special use exception if he didn't comply.
Right.
So there's ways to try to put more pressure on him, and you know, if you try to undo the granting of the special use exception, he's probably going to fight that, and you're going to end up in court, and there's probably more costs involved because you start with the BZA and then you go to court. Whereas if you do it this way, you go directly to the court, and you might be able to actually obtain more relief through an agreed order than you could otherwise. So I think that's after discussing this with Bob, I think that was the general sentiment, that might be the better way to go. I think you're probably going to have less resistance on his part if he knows that you're not trying to shut him down, whereas if you're saying we're going to revoke your special use exception, I think he'll dig in.
That's exactly right.
So you're recommending that we enforce the special exception?
And authorize Bob to do that through the court.
Through the court? So
Yes.
that's how he's notified, is through the court?
Yep.
And the other option, and I think that, you know, you can always write him a letter, but I think what's happened is that when this has been brought to his attention before, the situation gets better, and then it gets worse. And I think if this were probably the first time that this had ever come to the city's attention, I would probably have started there, but it's my understanding that this has been going on quite a long time, And so there's nothing that requires you to give him notice. I mean, he knows what a special exception is. He knows what his conditions are. He got it. And it may be that might let him know the city's serious too. And then basically we would file a lawsuit. He would get a summons, and at that point he would either, if he decided not to hire a lawyer, he could call me. If he wanted to resolve it, we could resolve it. If he got a lawyer, I could resolve it with his lawyer.
Okay.
So it sounds like we're going to end up in court one way or another, and it's more expeditious to do it to begin with.
I think that's right. And, the tough part about if you end up in court on a revocation is, you're going to have a hearing. You can't make any decision until you know you have the evidence of noncompliance, and then he can then take you to court and say you took away something. But at this point, all we're saying is you were given a permit, and we want you to follow the rules. And that's what we want.
Okay. Since this is sort of a free-form meeting, is there any additional comments from Mr. Ehrman? Comment from Mr. Bill Carbaugh, the city's enforcement officer.
I think what we need to address also, besides his family business or his business, residential business, we need to address the property directly south of him that now he's using for storing vehicles and storing material. Like he's got tons of asphalt, concrete there.
Yeah, and Mr. Carver, he's right. When I was talking about enforcing the special exception, I'm saying you get to do what we approved. You don't get to go move on to another lot, and those would actually be zoning violations. And so we would let him know, and the injunction would be not only to enforce to him follow the rules. Following the rules means he doesn't go on other property and start storing asphalt, concrete, and having all sorts of trucks and trailers on residential property.
So to clarify a point, the special exception was granted to him at that specific property.
That is correct.
He does not have the right to take that to adjoining properties or other properties unless he comes back before the board.
That's exactly right, because the building was originally, and Tim was, or the city was, I read through the whole file, it was originally approved as a garage to house, I think, somebody's motorhome, and then it was purchased, and then they started doing a workshop there, and so the special exception was approved because it's on a separate lot, it's on its own lot, and it was approved just for that lot, nothing else.
Okay.
Does he own the lot south of him, or does his dad own that?
It's his mom, I think, may be involved in that, but I don't know if he's using it for a business use and it's in violation of zoning, whether it may be that she's joined in the action as well.
I'm saying that's somewhat irrelevant if the special exception hasn't been granted for that use.
Correct. Well, and Tim's right. What we'd have to do is that would be part of the lawsuit. But if the property owner, if it's somebody different, is responsible for keeping their property in a compliance with the zoning ordinance. So we'll take a look at those lots on the GIS and make sure we've got all the proper owners there.
Do I have any more comments regarding this from those in attendance this evening?
So I would...
Identify yourself, sir.
Mayor Ken Meyer. I was here at your last meeting, and I brought this issue up, and it was from that, and I think that, I kind of gathered from all of you that, let's do what we need to do, but what can we do? And then Tim and I talked, and that's kind of how we arrived at where we're at today. And I strongly support this. I think that it's something that we owe all of the other neighbors in that, not only 10th Street, but 11th Street as well.
Okay, in order to move forward in the direction that has been recommended, Mr. Baker, what do we need to do?
I would ask for a motion to authorize Bob to proceed in that fashion. Bob will charge on an hourly rate, and that's something that we have funds budgeted in the Building and Planning Department budget, so it'll be paid out of that.
So as a clarification, Board of Works has to approve the expenditure of funds, correct?
No, it's budgeted.
Oh, okay, it's already in,
It's in the budget.
okay. So, do we have a motion to move forward?
Hey, it's your turn. I so move. I'll second that.
Any additional questions on the motion that has been made for Mr. Ehrman to move forward with legal action? All those in favor?
Aye.
Aye. Opposed? Motion is carried and approved. Is there anything else that we need to be aware of?
I don't think the other one would require Board of Zoning Appeals action on the Cottonwood Estates, but if you wanted to discuss that, we can.
Yeah, that's fine.
Just on the Cottonwood Estates, I'm sure you're all, I took my first tour of that, I think last week, and I mean, it's a pretty shocking situation. I guess that's, you know,
Yeah.
but it's, so, we also talked about this, and we think really the problem's been is that the owner hasn't allowed the city to go in and inspect. I mean, some of the buildings are wide open, holes, doors open. So there is a statute in Indiana under the unsafe building law that allows the enforcing authority to get an inspection warrant. Just like, and it's good for 48 hours, but as a condition precedent, the owner has to refuse the inspection. So what I talked to the mayor about shortly before the meeting is that we're going to write the owner's lawyer and ask them to inspect all of the trailers occupied or unoccupied in the trailer court. We assume that he's going to say no. If he doesn't say no, then really at that point the building inspector can go in and the process will take off from there. If he does refuse, then we would go into court, request an inspection warrant, and that would be good for 48 hours, and that would be allowed for the building department and any other safety officials to go in and make sure if there's any violations, which, I mean, I can't even build a window box, but I mean, there's window boxes that look better in some of those trailers, but, so anyway, that's really the course of action that we've recommended on those lines. But that's really something that I think we can either do, that have the building inspector do that, or the enforcing authority, and then take it from there.
Okay. So it's really a matter of Kurt advising or authorizing you to do it?
Yep.
Okay.
So do we have any discussion on this subject from the audience?
Yeah.
Tim Bowman.
Tim actually, you know.
Tim Bauman, Decatur Fire Department Inspector. Now, does that also let, I think you mentioned any inspection?
If they don't consent to an inspection, we're going to ask the judge that it would not only be a building inspection, but also fire and any other, public safety officials. And if we do have to go to court, then at that point, I've already talked to the mayor, we want to make sure that we have people who can testify as to, for example, we know that NIPSCO wouldn't hook up gas because it was a potential fire hazard. To get that kind of testimony into the judge so he knows that this is a serious situation. But our goal is to get both fire and building and really anybody that... And
Your county health department.
Yeah.
One of the concerns is the fact that there are people living there, and that when this inspection takes place, we may displace them. that concerns me, okay? So, and this morning we had a department head meeting, we talked about it, and I suggested that, I think this whole thing may require timing.
Right.
Synchronized type of timing, and make sure that we have confidentially talked to some of the bigs and the
Belmont Estates and,
Waterbury, yep,
Pine Crossing.
yeah, Pine Crossing, just, and see if we can maybe have housing kind of set, ready for these people if they are all of a sudden put on the street. And that's a concern, like I said, 2 years ago, when Bill and Jeremy went out there and counted how many were occupied, I think it was like 20-some. So, we could, all of a sudden, if we had 10 families without a place to live, then we look like we got kind of egg on our face for displacing them and not having any plan up our sleeve. So that's a thought that I am concerned about.
How many total lots are out there, do you know?
Used to be over 100, wasn't there?
Well, I think right now, made up, with concrete slabs and everything, I think it was like 48, maybe 50.
There used to be like 100.
Yeah, there's a lots numbered going up into the 80s or 90s, if I recall. Yeah.
I think at one time we counted how many lots were occupied. And we had trailers that were RV. Yeah, we had trailers that were just windows broken out. And there's a guy out there.
Yeah. Formula. That's probably worth more than that.
This guy is from Florida, the owner is from Florida, is that correct?
Yeah, Miami.
But he has a local legal representative that you're going to pursue this through.
Yep. But what I'll do is I'll make sure that I coordinate, well, obviously with the mayor and the city. What we don't want to do is we've sent him the notice, have a no, go into court 48 hours, and then run in. I mean, I think you're right. I think we want to make sure, because we're only going to have that inspection warrant for 48 hours, and depending on what's found, it may be found that as soon as those habitable units might not be habitable.
So what action is required by the BZA to move forward?
Really nothing, as the building, really the statute allows the building inspector is the enforcing authority to make that decision.
So this is an FYI, read it in the record meeting.
One other thing, and that is, so they have to refuse that before we can get the warrant. So we send a letter to Justin Wall, his attorney. Okay, how long can he sit on that letter?
What I would give him a deadline. And I'll just say if you don't agree with it, if you don't agree by a certain time, it's gonna be deemed that you refuse.
Okay. Should we list the number of trailers that we'd like to inspect?
I think we want to inspect them all.
Well, some of the trailers are in decent shape, so.
Which one?
Yeah, that's a relative term.
Sit down. Sit down. I deliver mails out there. You pray.
Any other comments, conversation regarding the Cottonwood Estates?
Now, this just takes care of Cottonwood, and it's out of our jurisdiction, but there's another trailer park to the north that is the same guy. Do we include?
He owns one in Huntington also.
Do we include the county with that?
Well, the county is aware that we're doing something.
Okay.
And health department. So, I mean, if they want to contact Bob and have Bob assist on that one as well, that's up to the county.
Another comment from Les Markle, Fire Chief.
Les Markle, Fire Chief. I have a question for Bob.
Yeah.
Is the health department open up doors more quickly for this to come to terms? Do they have a little bit more is it quicker to expedite if the health department, and it is a health violation versus other things that may be wishy-washy, whether we're saying it's inhabitable, but if it's a health code, is that kind of bring that to the top a little quicker?
The unsafe building law in the state's pretty stringent. I mean, if there are building code violations, they can determine that the building code with all the building violations can say it's uninhabitable. The health department's going to look at proper sanitation, but they're not going to look at structural. They're not going to look, and so I would say the building department is probably a combination of both is good. But the building, I mean, there's in Fort Wayne, for example, the building department goes in, and if they determine that they can shut the building down, close it off, order it for demolition. I mean, it's just based on building code issues.
So, second question. As we approach this time to decide what avenue we're going to have to deal with this in, we do some medical first response along with EMS. And we ran across this several times out there where we had an unsafe or real health issue. Should we kind of tread lightly on those till we know where we're going to be on this? Or I mean, Child Protective Services, that's a no-brainer, but if it's just somebody do we kind of avoid?
Actually, I mean, in that kind of situation, if you had something, let's say, between now and when we file the complaint, unless obviously imminent danger, right, where somebody's going to be really hurt immediately, it would be good to know because we would probably add the policemen or the firemen in and say, you went in there for an emergency, for to respond. What did you see? And they can, and then it's allowable because they're clearly allowed to go in.
So we want to make sure that any of that prior to...
If there are any calls for emergency out there, we would certainly want that.
Okay. We'll do our part.
Yep.
Any additional discussion? Mr. Baker, have we accomplished what we came to do?
Yes, and as I said, I appreciate Bob's willingness to help.
And to clarify, Mr. Ehrman will be working for the city of Decatur, and prosecuting may not be the right word, pursuing action.
Prosecuting
enforcement action.
Mr. Carbaugh.
I think we also appreciate Les's concern and his, he occupies his trailers on an emergency basis. I think we also need to get a hold of the police department and stress if they have runs out there and they see things like, we've seen pictures of the inside of the units out there that the police have actually responded to. And maybe if they see something also that would help us
Absolutely.
through litigation.
Yeah.
Anything that can be documented is going to be helpful to Bob when you go to court.
Anything else from the mayor? You're the one that brought this to our attention.
Does the fact that, as far as we know, the owner of the property doesn't have titles to most of these trailers, if any, does that have any significance in all of this?
You could certainly, one of the things we've talked about is if somebody wanted to go out and knock on a door and say, you mind if I come in and look? I mean, if somebody's in possession of the trailer, if he can't prove whether he owns it, I mean, you could certainly try that. I mean, there's only 6 or 7 from what I saw, maybe. But that might be something else, and then somebody can come in and say...
I just mean from the perspective that Nick Kloss says he owns these trailers. Well, does he?
Well, I mean, I think it would certainly be an argument that he probably has
may have a color of light by virtue of something being abandoned on property that he now
Even
owns.
when he bought the property, he might have gotten a bill of sale that simply said,
Mhm.
all personal property on the real estate, and he could show the bill of sale. He doesn't have the title, but he might have a bill of sale, so.
Right.
There's properties out there that are owned by individuals.
Okay.
Yeah, we checked with the auditor's office, and there's taxes being paid on a few of the units. I didn't know that.
Yeah, I ran some copies off here I can give to Bob of what I found on the property tax card, so
Yeah,
you're welcome to look at it.
It might, although I wonder if the ones that are paying personal property tax, if somebody knocked on the door and just said, hey, we want to look around. Now if they say no, then I would assume if somebody's paying personal property tax, those might be the ones that might be in better condition, maybe.
I would think.
And just as an FYI for the group, in the state of Indiana, mobile homes of that type are titled as motor vehicles, and after a certain time frame, they can no longer be taken on the road. So if they were abandoned, if somebody was paying for them and owned it and abandoned it, there would be no title to Mr. Coos. It's a unique circumstance with that kind of residence.
If we visit
Be
the...
moved out there, have to be dismantled and taken apart to be taken out of there, right?
That's true.
Yeah, they can't just hook up and take it.
Yeah, after so many years, they're not allowed on the roads anymore.
Dismantled.
If we visit the properties, then we probably should not go alone, like Kurt shouldn't probably go out there by himself. He should have maybe Tim go with
I'll be
him.
right there by me.
Okay. Actually, when I go through, I plan on having Tim Ballman with me, probably the health department, somebody from the health department, and probably 2 police officers.
Okay, good.
We do have latex boots and gloves.
Health department's told me they got hazmat suits.
We have some there.
All right. Any other business before the BZA this evening? If not, do I hear a motion to adjourn?
So moved.
Second. All those in favor?
Aye.
The meeting stands adjourned.